Okay, good morning. I'm Judge Evander. I'll be presiding over today's session. I would like to introduce the other members of the panel. Joining me today are Judge Scott Maycarve, formerly the first DCA. Now we're pleased to have him join us the fifth, and also Judge Edwards. This is the case of State Farm versus Hochreiter. I hope I'm pronouncing that correctly. 22-72. These arguments are being live streamed so the public can view them. If you have any electronic devices on, please make sure they're in the silent mode so that the oral arguments will not be disturbed. Appellant's counsel, Ms. Albrecht, you have 5 minutes for rebuttal unless you give me otherwise. There should be a clock on your screen. To help you keep track of time. And with that, you may proceed with your argument.
Thank you, Your Honor. May it please the court. Breton Albrecht of Kubicki Draper on behalf of State Farm. And yes, Your Honor, I would like to reserve 5 minutes for rebuttal. The procedural errors are key to why reversal is required in this case. The only reason given by the trial court's order for entering final judgment confirming the full amount of the appraisal award is the lack of a formal answer and affirmative defenses. Now, by definition, that is a judgment by default, but a judgment entered by default must comply with the requirements of Rule 1.500. Failure to do so results in a deprivation of due process, and the resulting judgment is void or at least invalid. But here, none of the requirements for a default were followed. None of the requirements for getting an initial order of default, let alone the requirements for getting an order of final default judgment, even standing alone.
Let me ask you this. Y'all did appear and you made a motion, and then there was a agreed upon order. Is that a stipulated order?
That's correct, Your Honor, to compel appraisal.
Right, but also for you to file an answer within 20 days if there were issues arose.
It did say if any issues remained that State Farm would answer within 20 days. Now, what's interesting.
Okay, well, let me follow up. I know that the order here didn't say it, but if, for instance, the order had said if there's no answer filed within 20 days after the appraiser's report, then a judgment will be entered for the amount of the appraisal report. Would that be something the parties could do as a matter of stipulation?
They couldn't, Your Honor, and I would base that on the case law we cited regarding the default issue in our briefs, and that is that a default, even if the order said that a default shall be entered if State Farm failure.
Well, I'm not talking about default. What if the agreed order said each side will have 20 days in which to object to the appraiser's report? If there's no objection, then the appraiser's report will be confirmed by the court. And so you made it to both sides. Would that be improper for the judge to have entered it in that case? I'm just having a little problem with your argument that there's non-compliance with the rule when you have appeared and you've submitted an order to the court. Now, the order is not as definitive on what happens if you don't follow. It's the hypotheticals I'm giving you, but just your overall statement that, hey, you can't get a default, because in this case, it really wasn't a default, it was confirmation of the appraiser's report. So I'm just trying to figure out why the rule would apply here.
And that's a good point, Your Honor. So a couple of responses to that. First of all, I mean, the order, even though it was an agreed order, probably, the order can't tell the future. It could have been better written. It is important, however, that the order did say if any issues remained. So that is what the order said. If any issues remain, State Farm would further respond to the complaint within 20 days after the appraisal. Now, significantly here, 20 days, 60 days, even 90 days post-appraisal, it was pretty much undisputed that State Farm did not owe any amount on this appraisal award because repairs had not been begun. Therefore, there was no question that the amount set for ordinance and law was not owed under the policy's option OL coverage.
Counsel,
that-
under the complaint that was filed, it essentially says, not in the typical words, but in paragraph 13 of the complaint, it essentially says plaintiffs have complied with all conditions preceding. It says they've done and performed all matters and things properly required of them under the insurance policy or have been excused from that performance. The issues remaining would be, are there any issues that State Farm has that it needs to bring up now that the appraisal's over with? And certainly I can see where that would be an issue you would raise, that, wait a minute, they haven't had the repairs done, therefore we don't owe the money. But when they say in their complaint, we've done everything we're supposed to, State Farm owes us the money on this covered loss, how is that not an issue that y'all need to raise?
Well, Your Honor, first of all, we did raise that by moving to compel and enforce the appraisal provision of the policy as and for the first response to the complaint. And State Farm had every right, because appraisal is a precondition to suit, had every right to respond to the complaint with a motion to invoke and compel appraisal. That was the first response to the complaint. It did assert that the preconditions weren't met. And at the time of the complaint, I mean, pretty much, I'm sure plaintiff's counsel will advise if he disagrees, but it was undisputed that repairs had not commenced, that, there was no ordinance or law triggered or owed because there were no actual repairs. And I think it's important, that is only, actual repair is only the first part of what this policy requires to trigger option OL coverage, is actual repairs. The other key requirement, without going through diving into the details of every word of the option OL coverage provision.
Right, they have to prove that the extra expense was due to an ordinance or law, building code, whatever. But what I'm saying is, in their complaint, they said they've done everything, State Farm owes the money. You're saying that if there were no issues remaining, we wouldn't be here. There were issues remaining. You said State Farm wants to say, wait a minute, we don't owe because, number one, the repairs haven't been done. Number two, you haven't offered sufficient proof that the extra expense is due to an ordinance or law. So I understand your issues. What I don't understand is your basic statement that there's not any issues remaining. We didn't have to respond to the complaint.
Well, and Your Honor, obviously hindsight is 2020. The circumstances of this case are incredibly important. I mean, we're talking about, going back to Judge Evander's question about, well, why are you calling it a default final judgment if the order had said that if State Farm doesn't answer within 20 days, a judgment will be entered confirming those types of things. You have to stop and ask procedurally, how do you get to final judgment? Of course, as Your Honor mentioned, you have the complaint. The complaint sets forth the pleading. State Farm never admitted anything regarding plaintiff's complaint. Instead, State Farm responded by invoking appraisal. It had every right to do so, since appraisal is a precondition to suit. In addition, the order granting that motion said State Farm would respond if any issues remained. As of 20, 60, even 90 days post appraisal, pretty much it was undisputed that repairs hadn't commenced.
Well, counsel, could I interrupt just for a second and ask a question so I kind of understand the process here? The appraisal process has to occur before the commencement of actual litigation. Is that correct?
That's correct, Your Honor.
Okay, so as I read it, my understanding, and it may be different among other persons, but it seemed like you were agreeing to the appraisal to be done. You weren't agreeing to anything else. You weren't essentially going to the next step, which would be the litigation phase, and saying, at that point, I can raise defenses and so forth. You're just saying there's enough here to say we need to have an appraisal done. And I think, again, if I may be incorrect on this, but the appraisal isn't definitively deciding the ultimate liability. The appraisal process is determining value or the damages, right?
That's correct, Your Honor. That's
Okay, so-
exactly what I'm trying to explain. Yes, Your Honor.
Right. So here, the appraisal process occurred, and they came back with an estimate, right? I mean, because the repairs had not been done.
Correct.
It came back with an estimate of an appraisal award should the plaintiff prevail. Correct?
That's correct, Your Honor.
So then we go to the next stage, which is litigation. And that's when all the procedural protections for coverage defenses. Oh, they didn't do what they're supposed to do to get that coverage. They haven't commenced repairs and so forth. Correct?
That's correct, Your Honor. So, and then the question again becomes, how do you get to a final judgment? And State Farm's position is that a motion to confirm and enter final judgment on appraisal, that standalone, it cannot be used to avoid or circumvent an insurance company's defenses or objections to paying the appraisal award. The cases, by and large, where there is something called a motion to confirm and enter final judgment on appraisal that gets granted and results in a final judgment, the vast majority of those cases fall into one of two categories. Either the appraisal was already paid and the insured or claimant is seeking a final judgment confirming the award in order to serve as a predicate for attorney's fees and costs, or it's combined with a motion for summary judgment. A judgment is not something that just automatically happens after appraisal. A judgment is not something that just automatically happens because there has been a complaint and even a lack of an answer in affirmative defenses.
Let me ask you this. Your opposing counsels argued that the OL was kind of baked into the appraisal, and that is, the appraisers have to evaluate what the law is on how much damage to the roof requires a new roof, and that's part of their analysis in coming up with the damages. If that's the case, then what's your objection to the amount? If it's not the case, then why is the case even submitted for appraisal on the OL if the appraisers are not going to be permitted to consider what damages are necessary to bring it up to comply with the applicable codes and ordinances?
That's a good question, Your Honor. So in this case, again, looking at the face of the appraisal award, what it says is that the amounts set are subject to the policy. It says any payments are subject to all policy provisions and limitations that may apply. So in other words, the award, the appraisal sets the amount, and then we have to go and look at the policy to determine what amounts are owed. Now, I also want to point out that right before the portion I just—
But how can you determine an OL amount without factoring into the ordinance, applicable ordinances and laws?
Well, I mean,
how can the appraisers come up with that amount unless they factor that in?
well, so they set the amount, and then there has to be, I mean, it is crucial, there has to be some ordinance or law that requires a full roof replacement of the undamaged portions, as opposed to just repairing the parts that actually suffered covered damage. Now, I think it's important.
So your argument is they can just, the OL can be determined by just setting how much it would cost for a new roof, and then leave the determination of whether there's an ordinance or law that required a new roof to the court rather than the appraisers.
Yes, Your Honor, and that is very commonly done. As just one example, it is very common for plaintiffs, insureds, claimants to identify something like the 25% rule, as in which the Florida Building Code generally requires if more than 25% of the roof requires repairs, then, oversimplifying, you get a full new roof. It's telling that here, no ordinance or law like that. The 25% rule, no ordinance or law has ever been identified, which might require an entire new roof. And interestingly, or importantly, the face of this appraisal award, just before the portion that I read, it says this award is an integral part of the corresponding estimate. Now, because this case jumped straight from the appraisal to final judgment with nothing in between, that estimate that is an integral part of the corresponding estimate, corresponding award, is not even attached. It's not in the record. The incompleteness of the record in that regard and in any other respect is precisely because this case went straight from appraisal to final judgment without addressing the merits of State Farm's objections that the amount set for ordinance and law was not owed under the terms of policies option OL coverage, and therefore that the net award was less than the policy deductible. I mean,
Council, boiled down to its simplest terms, your argument really is they had to move for default judgment or move specifically for summary judgment. They couldn't just take advantage of the fact that State Farm hadn't answered, even though it had agreed to answer if there were issues.
correct, Your Honor. And we're not asking this court to reach the merits of whether the amount set for ordinance and law was actually owed. However, even if the trial court's order could be considered a decision on the merits, no ordinance or law was ever identified that would require a full roof replacement. So for those reasons and those discussed in our briefs, we are requesting this court to reverse the order confirming and entering judgment in the full amount of the appraisal award and to remand with directions to allow State Farm to file an answer and affirmative defenses and to defend this matter on the merits. At a minimum, as we also discuss in our briefs, the amount of the final judgment must at least be reduced to the amount of plaintiff's invoice, less the deductible. So for those reasons, we do request reversal. Thank you, Your Honor. I'll reserve the remainder of
Let
my
me ask you
time.
one question. One, how far before the hearing did State Farm finally advise the trial judge that there were issues remaining?
It was the day before the hearing, Your Honor.
All right, thank you.
Good morning. May it please the court. Robert Hubbard on behalf of the plaintiff appellees. Counsel for State Farm focused on the procedural errors as the keys for seeking reversal. I'd like to start by focusing more on the merits of the issues that they're attempting to assert at the trial level. Judge Evander, you were, I think, getting to my primary argument when you asked, how does the appraisal panel arrive at an amount for ordinance and law coverage without considering the applicable ordinances, laws, building codes that would help them arrive at an amount? And from our position, State Farm is conflating two separate issues. The first issue is the cost of repairs, including the increased costs that may be due to complying with a code provision. And then the second issue is whether the insureds had incurred those repair costs to where State Farm was obligated to pay under the policy. The first question is a question of valuation for a covered loss. The second question is arguably a coverage issue that should have been raised if it was in dispute. The issue really hinges on
Bob, can we tell from the record whether the appraisers evaluated the ordinances and laws and determined that's how much it would cost to comply with the law, or could it just be that's how much a new roof would cost, and they weren't making any determination on the laws or the codes that were in effect, and whether that was required under the insurance policy?
Well, Your Honor, I would argue that that's clear from the face of the appraisal award. There's a separate line item for the ACV, RCV for repairing the damaged property. There's also a separate line item for the ordinance and law coverage. It's important to remember that the underlying cause of the loss is the same. It's the hail damage that led to the initial claim. It's not a separate cause of loss that would trigger the ordinance and law coverage. It's the actual need to perform additional repairs due to the application of building codes or laws and ordinances. And if Your Honor was pressing me a little further to try to point out the specific code, law, or ordinance provision, that is not clear from the record. We would argue that that's an issue that if State Farm wanted to dispute, it was incumbent upon them to move for modification or clarification of the appraisal award. They obviously did not do that. They didn't even file an answer with affirmative defenses in the 20 days.
All right. Well, if there's a question on the substantive issue, does that mean that this appeal is really dependent on the procedural issue?
Well, no, Your Honor. We believe the appeal fails on the procedural issues as well. If I can,
Right, but if
I'd
we
like
can't be sure from the appraisal order whether they decided a coverage issue or not, or whether the coverage issue is baked into the appraisal order, whether you could even have a separate coverage issue, since we don't know if their appraisal amount was based on how much it cost to replace the entire roof, or if it was based on and submitted to them to determine what was necessary to comply with the ordinances and laws, and then if we're not sure of that, how can we affirm on that issue? And why aren't we really just going to the procedural issue of whether they should have been entitled to address that?
Well, Your Honor, that question goes to what courts have said that the trial court is not allowed to do. The trial court is not allowed to look beyond the face of the appraisal award and hear evidence on what would trigger this line item. And that's essentially what State Farm, it appears to still be looking for an opportunity to do. And from the insured homeowner standpoint, how would that hearing go? Well, you would presumably call your appraiser in as a witness to explain the issues that they considered, how they arrived at that amount. I also want to point out that if you look at the appraisal provision in State Farm's policy, the language that I'm referring to is in the record on page 200. The policy appears numerous times in the record, but in the middle of the second paragraph of the appraisal provision, it states, if a dispute exists regarding the extent of the damages or whether any part of the loss is covered by the policy, the appraisers will itemize the damages according to the scope of the loss specified by each party. And then if the appraisers submit a written report of agreement to us, the amount agreed upon shall be the amount of the loss. If the appraisers fail to agree within 30 days, unless the time is extended by mutual agreement, they shall submit their differences to the umpire. With this unique policy language, the fact that you have State Farm's appraiser and the insured's appraiser entering line items for both agreeing to ACV, RCV, and optional law and ordinance coverage, if you reviewing the face of the appraisal award, it's clear that this is now the amount of the loss. And arguably the only possible coverage defense that State Farm could raise at this point, I mean, compliance with policy provisions is not an issue. They focus on this ordinance and law coverage. And the only issue that they could raise at this point is whether expenses had been incurred. And that's where, if you look in the record, there's a September 1st letter from State Farm. So the appraisal award was entered on June 18th, 2021. 20 days go by. That was the amount of time allowed by the trial court for State Farm to file an answer and affirmative defenses. Actually, it's 75 days that ultimately go by before anything in writing is ever sent to the insured. And the September 1st letter reads that the award set the amount of the loss at $23,823.46. For your convenience, here is a breakdown of the payment. The first line item is appraisal award replacement cost, $23,823.43, less the $2,000 policy deductible. You look down a little further, less prior ordinance and law, and it's the $22,058.94. And next to that, it says payable when incurred. If you go down to the next paragraph.
Counsel, if I could interrupt, I'm sorry. I have just a couple of quick questions. The first one is, if you could point me to the authority that gives appraisers the power to decide the coverage issue. So that's the first question, is where does this power, this authority come? Not from setting the amount of the damages for each element of loss, but to make the actual coverage determination. Okay, so that's sort of my first question. And then the second question is, what authority is there for the proposition that at the appraisal stage, where this order was entered, that the statement that there's no issues by the defense, that operates essentially as a waiver of defenses, that operates as a waiver of coverage issues? And I mean, there's a case that y'all cited, I guess it's this Federal District 1, the Three Palms Point, which doesn't appear to be followed by anyone else, but I'm looking for, those two answers to those two questions.
Sure. And on the first question, the only point I would make initially is that I wouldn't refer to what the appraisers did as making a coverage determination. Again, the covered cause of loss is the hail damage. So that's the coverage issue. What the appraisers did is factor in, they made calculations on the costs of repairs to the home. And that includes the additional costs that will qualify under the ordinance and law provision. And the authority that allows the appraisers to make that decision, in our view, is the Noah versus FIGA case. That's a 2017 decision from the 3rd DCA. And in our view, I mean, this is directly on point as to the substantive issue that the insurance company is trying to raise. It was procedurally a little bit different. In that case, the insured, there was an appraisal. I believe it went in the pre-suit stage. The appraisers did not award any amounts for ordinance and law coverage, and the insured then goes back wanting a second appraisal so they could try to obtain this additional coverage. And what the court in Noah says is that this is exactly the type of question that the appraisers are in the best position to address.
Well, if I hold your thought, if you could hold your thought, I just have a little follow-up on that.
Yes.
On my first question, which is, in this particular case, the policy basically said that the ordinance and law coverage doesn't kick in until they actually start the repairs, correct? So
that's correct.
So how could there be a determination by the appraiser at the front end where there aren't any repairs being ongoing? All they're doing is trying to say, put a number. They're just trying to put a number saying that if the repairs are done, this is what we expect the cost would be. So they can't possibly have made a determination about whether the insured has complied with all with State Farm's conditions precedent.
Well, and Your Honor, I think your question goes to why I said the State Farm is conflating two separate issues. There's the first question, which is the increased cost due to the application of these building code provisions, law and ordinance provisions. But then there is a separate question of whether payment is due and owing under the policy. And you're correct, the policy language and the case law requires that for this coverage, those expenses need to have been incurred by the insured. And so the appraisers aren't reviewing to determine, they're not looking for invoices showing that those repairs have been made. They are considering the building code requirements, the laws, ordinances. They're coming up with an amount the same way they do for replacement cost value or actual cash value if this coverage isn't implicated. They're always it's an estimate. They're using their software and expertise and background to come up with a number that they agree to. And that's what they did here. And so that number, which we say the increased cost associated with the ordinance and law coverage is baked into that number. That's the first issue. And then there's the separate issue of whether the insureds have actually incurred those expenses. And it is clear that they have. It is only if it's a two-step process, if the insureds have to reprove their entitlement to or the need for these additional repairs, could there ever be a situation where State Farm has this viable affirmative defense that could have been asserted? And the second question that you asked, I think really goes to the procedural process and why is it that a motion to confirm the final judgment was entered in this case. And I think it's important to look at the procedural posture when that motion was filed. So the lawsuit was originally filed as a breach of contract action. The insurance company demands appraisal. The parties enter into an agreed order to go through the appraisal process to resolve the amount of loss question. The order comes out June 18th, 2021. No answer is filed. The first written information that the insured receives about State Farm's position following the appraisal is the September 1st letter that I was reading from earlier, which says, for the line item ordinance and law coverage, payable when incurred. And so after they receive this September 1st letter, the next thing that they do, and this is in the record, is they enter into a contract with a contractor to perform the repairs in accordance with the appraisal award. So at the insurance company's direction, they enter into a contract with the roofer to incur these costs. That they later submit a notice of commencement showing that the repairs had begun, and then they show an invoice, a final invoice, showing that an amount was due for the work. Again, there's no communication from the insurance company saying this information is not acceptable and that now they maintain their issues to be litigated or dealt with. There's nothing filed in the court file.
Pardon me just a second. What you just said, is that in the judge's order about the commencement of the work? Or is that just evidence in the record somewhere, or is that actually in the judge's order?
Yeah, I believe that's in the motion that the plaintiffs filed. When they move to confirm the final judgment, they submit that information.
Okay, so there's been no adjudication about those facts. That's just some allegation in a motion.
Well, I mean, so to the extent that the insurance company is raising a due process challenge and complaining about procedural errors, I mean, they were allowed to present the merits of their argument. Both sides argued the substance of these issues. The trial court's order states that they didn't raise any affirmative defenses by citing to the Three Palms Point case and the Hess versus First Protective case. I mean, the Hess case stands for the proposition that if the insurance company wants to challenge something in an appraisal award, it was incumbent upon them to seek modification or clarification of the award. And they didn't do that in this case. So I think it is fair to say that the trial court looked at the arguments, considered the merits of what State Farm wanted, it was asking the court to do. And the Hess case says this as well. The court can't go hear evidence, conduct an evidentiary hearing. I mean, that was what the request was in their response, which was not filed timely in accordance with the local rules.
Mr. Hubbard, I have a question
yes.
for you.
Yes.
Isn't this the functional equivalent of a default judgment? I mean, they were supposed to file a response within 20 days of the appraisal. They agreed to do that. The court ordered them to do that. They didn't do it. And as a result of not doing it, a judgment gets entered based on the appraisal without them really being able to put forward their defenses. Am I missing something?
I would say it's not the functional equivalent of a default judgment, because remember, the original lawsuit was a breach of contract action to resolve the issues that were ultimately resolved in appraisal. After the insured goes forward and completes the repairs at the direction of the insurance company, they don't understand why they're not being paid. And so what the case law has said, there are numerous decisions that are cited to in the brief where courts are affirming the confirmation of a final judgment after an appraisal. I mean, from the insured standpoint, when you file that motion, there's nothing left for the court to do. So you don't need a judgment on the breach of contract. You just need the court to confirm the amount of the appraisal award so that you can then try to enforce it and get paid by the insurance company. And so the procedure here was they filed the motion to confirm. They provided the court with the same evidence they provided State Farm, saying, look, we did everything they've asked us to do. We complied with appraisal. We did the work. We incurred the expense. We're on the hook now for $20,000 in repair costs. And you know, they haven't asserted any affirmative defense, and they haven't told us why we're not being paid. And then the court was informed at the hearing about what State Farm's position was, because there was that issue with the untimely filed motion not finding its way into the court file. So it isn't that the court had weeks or I believe 10 or 14 days is the number I think that the local rules required. But so the court hears this at the hearing. He entertains the merits of the argument and the request for an evidentiary hearing, and rightly concluded that Florida law does not allow me to hold an evidentiary hearing where we call in the appraisers and ask them, hey, I see that you determined and agree that this is the number that is required to repair the damage because of applicable building codes or ordinances. Walk me through that. I mean, that's effectively what the insurance company was asking for. And
Mr. Hubbard, let me ask you this. If we were to agree with your opposing counsel that you're required to file an additional motion besides the motion to confirm arbitration, and the case went back to the trial judge and you filed a motion for default judgment, what factors would guide the court in determining whether to grant that motion or not?
Well, again, I don't believe a motion for default in this situation would be the appropriate relief. It was a breach of contract action. The insurance companies always argue in response to a breach of contract action, hey, we comply with our appraisal provision. I mean, it would be, I suppose, a new breach. The insurance company would assert the affirmative defense that they argued in the lower court. And I think the court would review the merits of that argument, conclude again that it could not conduct the evidence.
Well, the first question would be whether they had the right to assert it. So in determining whether they had the right to assert it by not complying with the trial court's order previously, what factors would the court consider in determining whether to give them the opportunity to assert these substantive defenses?
Absolutely.
I mean, what factors would the court have to consider?
Well, I think the fact that the insurance company on numerous occasions did not comply with the court's directives on when an affirmative defense would need to be asserted, on when a response to a motion would need to be filed. I mean, the procedural errors in this case are no one's fault except for the insurance companies. And because on the substance of the issues, the trial court can't conduct the inquiry that they're requesting, we're asking that the court affirm the final judgment in all respects.
Okay. All right. Thank you. Let's hear a rebuttal.
Thank you, Your Honor. First, on the procedural issues, again, a judgment for failure.
Same question for you. If we agreed with you and it went on remand and they filed an extra motion, would there be a decision for the trial judge to make as to whether to allow you to assert those defenses due to noncompliance with the order, or would you automatically have a right to assert your substantive defenses?
So we would automatically have a right to assert our substantive defenses so long as we got our answer filed before a default was actually entered. A default is a two-step process. First, especially here where a defendant—
Well, there's a little difference because the default in the normal complaint answer, there's no court order involved. There's a complaint filed, there's no response to pleading filed within 20 days, and then there's a request for an entry of a default. Here you did have an order saying that you would, if there are any issues, to file within 20 days. So you it seems to me you kind of jumped that step. There's already a court order in effect.
Well, Your Honor, the standard as I read the case law is actually the same, whether there's an order or not. And I would direct Your Honor's attention as one example to the Azure, Azure More Investments versus Hoyen case. And there they basically explain that even though that a default is not automatic, even when there's a court order saying that if you don't file an answer within X number of days, there's going to be a default. There still has to be the actual entry of an initial default upon which a final judgment is then predicated. Here, none of those steps were filed. There was not an initial default. There was not a motion for default. It just jumped straight to a final judgment confirming the full award because State Farm failed to timely file a formal answer and affirmative defenses. However, again, we did file a response in opposition to the motion to confirm. It makes sense. There was a motion to confirm. State Farm filed a response in opposition. There was no waiver of any defenses or objections to entry of the full award. The trial court's order does not find that there was a waiver. And in fact, State Farm's actions in response to the motion to confirm were entirely consistent with preserving its defenses to payment of the award. Now,
Counsel, I know you have limited time, but I have an important question, at least in my mind. Let's say we agree entirely with you and we send this back and you get to assert defenses and so forth. It seems to me the only defense that I'm really hearing is that the insureds haven't commenced the repairs or haven't done the repairs. And if if that's the case, I mean, maybe I'm wrong. If that's the case, the amount has already been established, right? And then once they do commence and they do complete, they get up to that amount of the award. So it seems to me like, I'm not sure why we would send it back just so you can say, well, they haven't quite done the construction yet.
Your Honor, it's more than commencing or completing the repairs. That is just one requirement. It is telling that plaintiffs admit that that is a requirement, but that is the first requirement. There are others. The other most important requirement is that there must actually be an ordinance or law that required the full roof replacement as opposed to the just repairing the damaged portion. And we're not trying to look behind the award. The face of the award says that you refer back to the policy provisions. The award sets the amounts. It does not determine entitlement. It does not determine liability for coverage under the policy. This was a policy that excluded payment for ordinance or law unless it was both incurred and also there must be an ordinance or law that actually requires the full roof replacement. So I hope that answers Your Honor's questions. And we do request reversal for these reasons and all those discussed in our briefs. Thank you, Your Honor.
All right, thank you both for your arguments. Well argued, and we'll be in recess.
Thank you.
Thank you, Your Honor.